Bom dia a todos.
Good morning, everyone. So today is the last day of our course, and I would like to begin by thanking the School of Judges, not the director, but their employees for their efforts. Marcia Kifura, she's just a brilliant job, and Marta, Riani, and the supporters, Marisa. The school does not have a substantial budget, but we do what we can. And we can only do this thanks to the cooperation of our employees here. And I had to remind myself to thank them. I apologize to start the day like this, but it would only be fair to do so because old man, old brain, you know how it goes. I would also like to thank the director of ABIN, Dr. Wilson Tressa, for joining us today. And once I was invited to give a presentation there, and he welcomed me, and I was impressed to see how skilled everyone is at ABIN, and I was impressed to see the intellectual capacity they have to do the intelligence work in Brazil, not is the stupid work done by some institutions. I believe that Dr. Wilson Tressa will be able to address several topics here today better than me. I'm going to be brief because each one will have an hour, and Professor Nathan has to check out before noon at the hotel, so really let's stick to 1 hour each. So briefly, the bio of the director of the Brazilian Intelligence Agency. Well, Dr. Wilson Trez is from São Paulo. He's an intelligence official. He joined that industry in 1981, started working in several areas of the psychosocial field. He also worked with counterintelligence, and he helped train servants in the Institute of Human Resources, where he headed the Department of Intelligence. He has a degree in business administration, PhD abroad, and he has a career in intelligence and information courses, category A, held in '89, and political sciences. He also worked in different ministries. I'm going to summarize his bio because it's a very long one. He also worked with business management in the private sector. He worked also in the police academy, in the Distrito Federal, and the National School of Public Administration. He also represented the Ministry of Education in some projects, and he was decorated by the Brazilian Army. At ABIN, the Brazilian Intelligence Agency, he was the planning secretary, and also he was the executive coordinator of the working group to elaborate the national policy on intelligence and to review the national system of intelligence. Welcome, Dr. Wilson Treza. And we're going to begin with Professor Nathan Sayles, who will talk about criminal prosecution of terrorism suspects, jurisdiction conflicts, and he's going to talk about ISIS. After that, we'll have the presentation of the director of ABIN to talk about intelligence and cybersecurity in Brazil. Dr. Nathan, the floor is yours, please.
Welcome back. I'm very sorry that it's already Wednesday. I've very, very much enjoyed these classes. I've enjoyed having a conversation with you after the lectures, learning about your concerns and your priorities, learning about the Brazilian approach to these very difficult issues. It's been a wonderful trip for me here to Sao Paulo, and I'm sorry that we've come to the end already. But so we have. So for our last talk today, I'd like to talk about criminal prosecution of terrorism suspects, with a special focus on ISIS and the challenges posed by the rise of ISIS in Iraq and Syria. Let's start off by thinking a little bit about the scope of the problem. We have seen about 20,000 foreign fighters travel to Iraq and Syria, well, primarily to Syria, to fight on behalf of ISIS. 20,000, that's a pretty substantial number. About 20 of those 20,000 people, about 7,000 of them have returned home. And as we'll see, the return of people with military training, military weapons can be a very serious challenge from a counterterrorism standpoint. So where do these 20,000 foreign fighters come from? Here we have a chart that lists some of the major countries from which these people hail, from which they come. As you might expect, most of them, many of them come from the Middle East. So we have countries like Tunisia, Saudi Arabia, Jordan, and Morocco. But many of them come from European countries as well, and in particular, Western European countries. It has been estimated that out of the 20,000 foreign fighters who have traveled to Syria to fight with ISIS, as many as 5,000 of them are from Western Europe. So that's about 25% of the total number of foreign fighters. Which Western European countries in particular? Well, Belgium is very well represented in ISIS's ranks. About 450 Belgians have gone. Over 1,000 people from France, 600 Germans, and about 600 subjects of the United Kingdom have traveled to ISIS, controlled territory, to fight for the Islamic State. One example of this is a well-known figure, Jihadi John. He is a British citizen, born in Kuwait, came to the UK as a young child, and is now known for his gruesome beheading videos that are posted on the internet, in which he decapitates Western hostages, journalists, and others, humanitarian aid workers and others who have fallen into ISIS's control. His real name is Mohammed, I want to make sure I get this right, Mohammed Emwazi. And as I said, a British citizen who originally came from Kuwait. So why does it matter? Why does it matter that 20,000 people from other countries have traveled to Syria to fight for ISIS? And why does it matter that 5,000 of them come from Western European countries? Well, the fear is that today's Syria might become another Afghanistan. What do I mean by that? Well, in the 1970s and 1980s, after the Soviet Union invaded Afghanistan, Afghanistan became a sort of training ground or incubator for terrorism. Thousands of people, mostly from Arab countries, traveled to Afghanistan to fight on behalf of the Mujahideen against the Soviet invaders, the invading Soviet army. As a result of this experience, the so-called Afghan Arabs developed a number of skills and networks that would become the foundation of the modern jihadi movement. So, for instance, lots of young fighters together in Afghanistan produce networks, social networks. You know people, you are able to interact with them, you are able to form terrorist organizations. You develop military skills as a result of your combat experience that can then be used to perpetrate terrorist attacks. You also get military weapons, not just the ubiquitous Kalashnikov rifle, perhaps explosives as well, and other kinds of military ordnance. You also get confidence to believe that you can take on a much more powerful adversary and ultimately prevail. This is what happened in Afghanistan in the 1980s, and the concern is that the similar influx of foreign fighters into Syria today will produce the same sorts of consequences. Remember, Osama bin Laden himself got his start as one of the so-called Afghan Arabs who was fighting in Afghanistan against the Soviet Union. This is a picture of him in the 1980s. Al-Qaeda, it's no exaggeration to say that Al-Qaeda's origins were here in the mountains of Afghanistan in the anti-Soviet jihad. Will the same thing happen in Syria? That's what we're concerned about. We're already starting to see some of the harmful effects that can result from Western European citizens traveling to Syria, fighting, and then returning home. Here we have a picture of the Jewish Museum of Belgium. There was an attack just over a year ago, in May of 2014, on the Jewish Museum in Brussels, in which 4 innocent people were gunned down. The gunman is a man named Mehdi Namouche. He was a French citizen. And he went to Syria to fight for ISIS in 2013. It's thought that he fought there for about a year before returning home to returning home to Europe, and then perpetrating this atrocity at the museum in Brussels. The fear is that he will not be the last. He's the first, and so far as we know, only returnee to commit a terrorist attack after having fought for ISIS. But the concern is that this is the leading edge of a much more problematic and deeper trend. So then the question becomes, how can and how is the international community responding to this threat? Well, just last year, in September of 2014, the UN Security Council adopted Resolution 2178, which calls on all member states to address the problem posed by foreign terrorist fighters traveling into Syria to join ISIS. So under this resolution, all UN members have a legal obligation to prevent the recruiting, organizing, transporting, or equipping of individuals who travel to a state other than their states of residence or nationality for the purpose of the preparation, planning of, or participation in terrorist attacks. Right? So that's what international law provides. As a Security Council resolution, this is now binding, a binding obligation on all members of the United Nations. How have various countries implemented this legislation, this Security Council requirement? Well, the United States uses a statute that actually dates from the 1990s. It's known as the Material Support Statute. And here we have President Clinton signing it into law in 1996. So the Material Support Statute is the principal legislation that the United States uses domestically to implement its international legal obligations under the Security Council resolution. Other countries have used different statutes. Other countries have had to enact new legislation today because they didn't have this sort of law on the books. In the case of the United States, this law has been around for almost 2 decades now, and this is the tool that is primarily used. So it provides, whoever knowingly provides material support or resources to a foreign terrorist organization shall be fined or imprisoned not more than 20 years. So the key question then becomes, what was Congress trying to do when it enacted this statute. Why should it be a crime to provide material support to a terrorist organization? And what does material support mean anyway? Hold that thought. We will come back to it in a moment and consider what kinds of conduct fall within the scope of this legislation. But for now, I want us to spend a couple of moments thinking about the policy goal here. What was Congress trying to do? What was Congress's objective in banning material support? The basic idea is prevention. The basic idea is to prevent attacks from actually taking place by making it a crime to prepare for the attack, right? So imagine the life cycle of a given terrorist attack. There are a number of different steps that have to happen before a terrorist can complete an attack. So before the attack can take place, the terrorist has to obtain weapons, whether that's a firearm or explosives. He has to be able to pay for those weapons somehow, so he has to obtain funding. He has to know how to use weapons, so he has to have received some sort of training, perhaps military training. He has to join the organization, and before he joins the organization, he has to want to join the organization. He has to have undergone a process of radicalization in which his views become more extreme. He aligns himself with the objectives of the group, right? So the steps that have to happen: radicalization, joining the group, receiving training, receiving funding, obtaining weapons, and then actually carrying out the attack. So the material support statute has the goal of moving the point of criminal liability back in time. We don't have to wait for the actual attack to take place before we can prosecute you or before we can investigate you. The idea is to move backwards in time the point of criminal liability and allow authorities to conduct investigations and to commence prosecutions here for simply joining Al-Qaeda or ISIS or receiving training for Al-Qaeda or ISIS. Again, the material support statute moves the point of criminal liability from the moment of the attack to earlier stages of the attack cycle. So, what is material support? And the answer is almost anything. So we have a very lengthy definition here. I will read it to you, and I hope that nobody falls asleep because this is not recreational reading. This is a very lengthy and complicated statute. So here are things that count as material support. Any property, tangible or intangible, or service, including currency or monetary instruments or financial securities, financial services, so in short, money, as well as lodging, training, expert advice or assistance, safe houses, false documentation or identification, communications equipment, facilities, weapons, lethal substances, explosives, personnel, and then a parentheses that specifies that personnel means one or more individuals who may be or include oneself, and transportation, and not including medicine or religious materials. So you can give a Band-Aid to ISIS or a Quran or a Bible, but you can't give them anything else on this list. So what does this mean in plain language? What specific types of conduct count as material support and are therefore illegal under U.S. law? Well, suppose you want to raise money for ISIS. Is that illegal? Well, yes, it is. We have a lengthy list of financial instruments that count as material support. If you raise money for them, that is pretty clearly a violation of the statute. What if you want to recruit your friends to join ISIS? Hey guys, ISIS is doing great things in Syria. You really should head over there. Here's a plane ticket. Is that illegal? Well, yes, that probably is too. In fact, it almost certainly is, because the statute defines material support to include, where is it here? Recruiting is in here someplace. Oh yeah, personnel. Providing personnel. Well, if you are providing your friends as potential members of ISIS, you are providing personnel to ISIS. What happens if you want to train people? Here's how to hide your communications so the Americans won't eavesdrop on you. Here's how to fire a weapon. Here's how to conceal a bomb. Does that count as material support? Well, yes, it does. That might count as training. That might count as expert advice or assistance. You're an expert in how to make bombs. If you convey that knowledge to a person on behalf of ISIS, that might well count as providing expert advice or assistance. What if you decide to join ISIS yourself? Sign me up and give me the ISIS membership card. Does that count as providing material support? Probably does. Again, if you provide personnel, including oneself, that seems to fall within the statutory definition as well. So what counts as material support? Essentially anything you might do to further the interests of ISIS would probably count as material support under the statute. Now, what about the First Amendment? We've talked about the U.S. Constitution several times over the course of these classes. Let's see what the First Amendment might have to say about the material support prohibition. Recall that the First Amendment provides that Congress may not make any law impairing the right of free speech and various other rights. But here, the most important and applicable right is the right to free speech. Well, the Supreme Court heard a case 5 years ago in which it considered whether the ban on material support violates the First Amendment. We had a group known as Humanitarian Law Project, a U.S.-based group that wanted to provide training to a number of terrorist organizations. Not ISIS, not Al-Qaeda. One of them was the Kurdistan Workers' Party, or PKK, in Turkey. Another was the Tamil Tigers. Well, what kind of training did Humanitarian Law Project want to provide to these groups? Not weapons training, not how to make explosives and how to evade surveillance, peaceful training. The group wanted to teach these organizations how to resolve their grievances through peaceful means. Wanted to teach them how to engage in political advocacy, right, rather than using violence. It wanted to teach them how to petition the UN so that the UN would take steps to benefit their interests and advance their agenda. So peaceful training is what they tried to do. And the concern was we want to provide this sort of assistance to these groups to help promote peace. We are afraid that doing so might violate the material support statute. And that violation of the statute would be unconstitutional. In short, they're saying it would be unconstitutional for the government to prohibit us from engaging in this sort of peaceful advocacy, right? So there's the issue. Does the material support statute violate the First Amendment by prohibiting Humanitarian Law Project or other organizations from engaging in peaceful training, peaceful speech directed at a terrorist organization? The Supreme Court says the statute is constitutional. In other words, the First Amendment allows the government to prohibit groups like HLP from providing even peaceful speech, engaging in even peaceful communications with designated terrorist organizations. So why should that be? Right, that's a bit of a puzzle. Let's try and unpack the court's rationale and understand why something that seems to be desirable, teaching them to resolve their differences peacefully, why that sort of seemingly innocuous and seemingly beneficial speech might be prohibited under the law. So let's distinguish between giving the group money and giving the group training. So suppose Humanitarian Law Project had wanted to give the terrorist groups money. Would that enable the group to engage in terrorism? Would that assist the group's terrorist-related missions? Well, the court says yes, it would. And the reason is because money is fungible. Does the term fungible make sense in English? Yes. So if I give Al-Qaeda $5 that I want them to use to provide health care to a village, that means that Al-Qaeda now has $5 already in their coffers that they can divert to terrorism. The $5 they would have spent on health care for a village can now be freed up to provide terrorist activity. So providing money, the court says, facilitates a group's terrorist activity, even if the money is given for peaceful activities and to further peaceful purposes because of the fungibility of money. Well, what about speech? Does providing training have the same sort of effect? If you train a terrorist organization how to petition the UN or how to resolve their political grievances in a peaceful way, does that also enable the group to be more effective at engaging in terrorism? Well, the court says yes, it does. If you provide training, that makes it less costly for the group to undertake its peaceful activities. Now that they've been trained in how to petition the UN, they don't have to hire a lawyer to do it. Right? Now that they've been trained to resolve their political grievances through peaceful means, they don't have to hire a lobbyist to file some sort of petition with the legislature. Right? That means that there are now more resources available to these terrorist groups that these groups might use to engage in terrorism. So the court says providing speech, providing training has the same sort of effect as money does. Both money and training have the effect of freeing up other resources that the group can now use to commit terrorist acts. And that, the court says, is why the government has a legitimate interest in using the material support statute to prohibit not just guns, not just money, not just bombs, but also training. Right? Even training that seems to be directed at beneficial ends, such as peaceful resolution of disputes. We only have an hour, so let's skip over the problem of extraterritoriality. Extraterritoriality is an issue that raises the problem of conflict of laws. What happens if U.S. law applies to conduct that takes place in Brazil or Afghanistan? And we have a conflict between the demands of one sovereign and the demands of another. I'm happy to discuss that afterwards if that interests you, but in the interest of time, I think we should skip over it for now. The last thing I'd like to talk about is practical difficulties that arise when the government tries to prosecute terrorists in ordinary criminal court, right? So the basic problem concerns the tension between the government's need to protect sensitive information on the one hand and the defendant's fundamental constitutional right to a fair and impartial trial, right? The government needs to protect its secrets, but the defendant needs to be able to defend himself against the charges the government has brought. And as we'll see, it can be exceptionally difficult to figure out how to balance those two competing interests in the context of a specific case. So let's look at the Moussaoui case as an example of this. Zacarias Moussaoui was an admitted member of Al-Qaeda. He was arrested by immigration authorities in the United States, actually before 9/11. He was enrolled in a flight school, I think in Minnesota, but maybe it was Oklahoma. It doesn't matter. He was enrolled in a flight school. He came to the attention of immigration authorities because he had overstayed his visa and was not allowed to be in the U.S. He was arrested, interrogated by police, and police thought, this is a guy who's up to no good. He wants to learn how to fly jumbo jets at the flight school, but he's not really interested in learning how to land jumbo jets. Something seems a little bit suspicious. He was in custody before 9/11, and after the 9/11 attacks, he became obviously of even greater interest to investigators because his activities were very, very similar to the activities of the 9/11 hijackers. In fact, for a time, the U.S. government thought that Moussaoui was supposed to be the 20th hijacker. Right? 5 on one plane, 5 on one plane, 5 on one plane, 4 on the last plane. Why only 4? Well, the theory was Moussaoui was supposed to be number 5. Later, it turned out that's probably not the case. There was another person who tried to enter the United States in 2001, but was turned away at the border because this person was thought to be suspicious. So the current thinking is that this other person was supposed to be the 20th hijacker, not Moussaoui. Nevertheless, Moussaoui is prosecuted as an admitted Al-Qaeda member, and he's charged in federal court with participating in the conspiracy that resulted in the 9/11 terrorist attacks. So during the trial, Moussawi's lawyer asks the judge for permission to conduct a deposition of another al-Qaeda detainee that the United States is holding either in military custody or CIA custody. So why does Moussawi's lawyer want to introduce this testimony? Well, the lawyer thinks this other al-Qaeda detainee, this other captive, this person will testify that Moussawi was never going to be involved in the 9/11 operation in particular. The testimony, the lawyer thinks, will be that Moussawi was in place to be part of a planned second wave of attacks, right? Not 9/11, but a second wave of attacks. So why does that matter? Well, the reason that matters is because if Moussawi wasn't part of the specific 9/11 plot, he might not be eligible for the death penalty. Right? He might only be eligible for a lesser sentence, whether that's life in prison or 30 years or 20 years, or maybe nothing at all. Right? So it becomes really, really important from Moussawi's standpoint to be able to introduce testimony that, no, I was not, in fact, part of this specific 9/11 related conspiracy. Although I'm part of al-Qaeda and have conspired with al-Qaeda to commit terrorist attacks, I only conspired to commit other terrorist attacks, not the ones with which I have been charged. So the government objects. The government says, we don't want to produce this other al-Qaeda captive because this person is currently being interrogated. Maybe this person was being interrogated by the CIA. Remember the different techniques that we discussed a couple of days ago. We have no way of knowing for sure, but maybe this person was somebody in the enhanced interrogation program. Whether that's true or not, the government says, we don't want to produce the witness. And the reason we don't want to produce the witness is because that will interfere with the ongoing interrogations. Right? We need to keep this person in isolation so that we can develop a rapport with this person. And if the captive is taken out of isolation and exposed to Moussawi's lawyer or Moussawi, that's going to disrupt our ability to ask that person questions. So the government says, no, we're not going to do it. And so we see a fundamental conflict here. On the one hand, we have the government's important, it is an important interest. The government's important interest in collecting information that it might use to protect the country against future terrorist attacks. But on the other hand, we have an equally important interest that Moussawi has in defending himself against the death penalty or any other form of criminal liability. So the issue is, does Moussawi have a constitutional right to obtain testimony from an al-Qaeda captive who's currently held in military or CIA custody? That's Moussawi. That's his mugshot after he was arrested. I should explain the images. And this is a courtroom sketch of Moussawi's trial. So let's start with the text of the Sixth Amendment. So the Sixth Amendment to the U.S. Constitution provides that in all criminal prosecutions, the accused shall enjoy the right to have compulsory process for obtaining witnesses in his favor. What does that mean in plain language? It means if the government puts you on trial, you can force other people to testify in your defense, right? You can compel them to appear at the court and testify, no, you're not guilty, right? So does Moussawi have a right under the Sixth Amendment to call on his behalf a suspected al-Qaeda leader to testify that he was not, in fact, part of the 9/11 plot? Well, the court in the Moussawi case says, yes, Moussawi does have this right. The Sixth Amendment does grant him the right to obtain testimony from an al-Qaeda captive to be used in his defense. Why is that? Well, the court says the government's interest is strong. The government's interest in preventing another attack is strong, but Moussawi's interest is even stronger. Right? The court says the executive's interest in protecting classified information does not overcome a defendant's right to present his case. Why is that? Because it's literally a matter of life and death. Right? If Moussawi is unable to introduce this testimony, he may well be sentenced to death. If he is able to introduce this testimony, he may well escape liability. He may well escape the death penalty. So the court says no matter how important the government's interests are, they are not so strong as to overcome a criminal defendant's ability to mount a defense, and in particular, to protect himself against the imposition of the death penalty. So how does the government respond then to this ruling from the court? Well, the government basically announces very politely and respectfully, "Thank you, Your Honor, for this ruling, but we're not going to comply with it." The government says, "We are not going to produce the detainee to testify on Moussawi's behalf." So, we'll come back to that in a second. So what would a court do in that situation normally? If the government ignores a valid court order, normally you would expect the court to dismiss the case altogether. I've ordered you to produce a witness. You haven't done so. Therefore, the case is dismissed. Moussawi gets to walk. That's not what the court does here. The court tries to adopt a flexible approach to balance Moussawi's interests and the government's interests. And so the court says the government doesn't necessarily have to produce the witness to testify live in court. And the government doesn't even have to produce the witness to testify over Skype or FaceTime or video teleconference. Instead, it might be enough, the Sixth Amendment might be satisfied if the government produces written summaries of what the al-Qaeda captive said while under interrogation. The court says, we hold that the redacted summaries provide, what does redacted mean? Who knows? The court sort of took a black marker and crossed that out of the opinion, so we're not really sure what words are underneath the black ink. It might be, this is just a guess, but I think it's a plausible guess. I think it's a reference to CIA or military interrogations of the al-Qaeda detainee. So I don't know if that's right, but I'm guessing that it is. So the court says, we hold that these summaries provide an adequate basis for the creation of written statements that may be submitted to the jury instead of the witness's deposition testimony. So should we punish the government? Should we dismiss the case altogether because the government has refused to produce the witness the way it normally would be required to? The court says no, we're not going to punish the government. And the reason is because the government has rightfully exercised its prerogative to protect national security interests by refusing to produce the witness. So what's going on here? Well, the court initially says when Moussawi's constitutional rights come into conflict with the government's interests are not so strong as to defeat Moussawi's rights altogether. Right? Moussawi does have a Sixth Amendment right to defend himself by producing information that is exculpatory, that will exonerate him. So the government's national security interests are not so strong as to defeat Moussawi's rights altogether. But the court then goes on to say, implicitly, the government's interests are strong enough that they have to be accommodated in the way that Moussawi introduces this testimony. Right? So we will depart from, because of the government's interests, we will depart from the normal requirement of producing a witness to testify live and in person in the courtroom. And instead of that default position, default practice, we, the court, will approve a more flexible approach in which the government can take some shortcuts and introduce written statements instead. So what's the end result for Moussawi? He's in jail. He actually fired his lawyers after this case and decided to plead guilty. He was not sentenced to death, but was instead sentenced to life imprisonment, and this is his current home. This is the ADMAX, Administrative Maximum, the ADMAX prison in Florence, Colorado. This is where the worst of the worst go. The Unabomber, shoe bomber Richard Reed, remember him? He tried to blow up a plane on Christmas Day, or no, not Christmas Day, around the Christmas season. Ramzi bin al-Shib, a senior al-Qaeda operative. They're all neighbors now. So that's the end of the story of Moussawi, and that's the end of my presentations. Again, thank you so much for coming to these presentations. It's been a great pleasure for me to talk with you, to speak with you, and to learn from you as well. And now I look forward to hearing from my counterpart from Brazil. Thank you all.
don't